Hello, I'm Dr. Terry Susan Fine, Content Specialist for the Florida Joint Center for Citizenship, which is part of the School of Politics, Security, and International Affairs at the University of Central Florida in Orlando. Welcome to our Middle School Civics Highlights series. Today we'll be focusing on Benchmark 1.4, in which we will analyze how Enlightenment ideas, including Montesquieu's view of separation of powers, and John Locke's theories related to natural law and Locke's social contract influenced the founding. In Part 1, we focus on the Enlightenment ideas of separation of powers, natural law, and social contract. So in focusing on these principles, we're going to both identify and describe the ideas of separation of powers, natural law, and social contract. We'll be looking at what was the Enlightenment? What are the Enlightenment ideas that we're going to be discussing today? So what was the Enlightenment? The Enlightenment was a 17th and 18th century international movement, mostly centered in Europe, that focused on ideas. The Enlightenment emphasized critical thinking. It stressed the importance of nature and the natural order as a source of knowledge. Enlightenment thinkers defended religious tolerance, defended the idea that people could understand the universe differently, even if it was the same universe. They could engage in the universe differently because of different religious lenses. They also emphasized intellectual freedom and human rights. In essence, Enlightenment thinkers believed that reason should be used to understand the human condition. And so by using reason and the nature and the natural order as a source of knowledge, the idea was that as long as everyone believed fundamentally in human rights, that people might practice different religions, they might have different intellectual perspectives, and they also have different viewpoints about how to practice their religion. There are three Enlightenment ideas that we'll be looking at today. First is separation of powers. Separation of powers considers that it is important to limit the concentration of government power, which may lead to abuse. The three powers of government, the legislative, executive, and judicial, are divided into three separate departments. So what does it mean to be divided into three separate departments? What it means is that the people who hold lawmaking power or legislative power, they are separate from not only the executive branch, but the people in the executive branch, those with the power to enforce the laws, are not members of the legislative branch. So the idea is that there's going to be naturally a conflict between the people who believe in the focus on the legislature and making laws and the people who enforce those laws, who might believe that some of the laws that are being passed by the legislature cannot be enforced in the way that the legislature intended. And so there might be some conflict or discussion to come up with the best possible way to ensure that those laws are implemented, those laws are enforced. The same principle applies to the judicial branch in that people who serve in the legislative or executive branches may not serve in the judicial branch. The purpose of the judicial branch is to judge the law, is to make sure that the law is being applied fairly and correctly, and to confirm that if somebody is accused of violating the law, that they indeed violated the law that they are accused of before they might lose their freedom by going to prison or having to pay a fine if there might be some confusion, for example, about what the law is, what the law means, etc. That is specifically the role of the judicial branch, to judge the law. So we have not only three separate departments. In the United States, we have three separate buildings, but it's also three separate groups of people. When we're focusing on natural law, we're focusing on the rights common to all persons that are based on nature alone. By virtue of being born, the people have rights. by virtue of being born. And because the people have rights because they exist, the government cannot take away those rights unless the government is going to go through a set of processes. So you'll be hearing the phrase due process of law, equal protection of the law in other contexts in this course, but all of those are fundamentally based on natural law, that once a person is born, once a person exists, that there are rights that they all have, regardless of the circumstances in which they were born, regardless of the place in the country that they're born, and other kinds of ideas, who their parents are, who their siblings are, who their family is, etc. They all have the same rights because they were all born. And then there is social contract. The concept of social contract is that the people are loyal to the government as long as the government continues to respect the people. So as with any contract, there is an agreement that people say, I will give you this in exchange for something else, or you will give me this so that I make sure that I provide you with something, or I promise not to do something to you that you don't want to happen. So that's a contract. It's an agreement. And what is the social contract? The social contract is that the people are loyal to the government, meaning the government passes laws and the people agree to abide by them. That's their part of the contract. What's the government's part in that contract? The government's part of the contract is to respect the people, is to, in essence, give the people their loyalty. And so we look at social in the context of society here. Social meaning within our society, the government is loyal to the people and the people are loyal to the government. That's the relationship. Thank you so much for joining me today for Middle School Civics Highlights. Do you still have questions? Please contact us using the information that appears on the screen. Till next time, I'm Dr. Terry Susan Fine. Thank you for joining me.